All right. Good morning, everyone. I'm Executive Director of the ILCA, Scott Grams. We're going to go ahead and get started with this morning's webinar. I just want to thank all of you for joining us. I'm going to go through an introduction and then some housekeeping notes, and then I'm going to turn the call over to Julie and Sara of Smith Amundsen. In March 2019, the U.S. Social Security Administration began issuing correspondences to employers regarding wages reported to the SSA in 2018 via employers' W-2 submissions. The SSA requested that employers address any mismatch that resulted if an employee's Social Security number differed from what the employer had reported. This process has sent a lot of uncertainty, confusion, and fear across many industries, across many states. Now, as soon as those letters went out, I started to receive a flood of calls from our members. And in response, we coordinated with our friends at the law firm of Smith Amundsen to help employers navigate what may have been a new process for some of you and was definitely a new format for everyone. And I also know that Smith Amundsen was inundated with calls from our members as well. So due to the extremely high volume of calls and emails over the course of the past few months, we decided to take an additional step and organize today's webinar. We've seen a wide range of guidance go out from a number of state and national organizations, and some of that has been directly contradictory with some of the other information. So we really wanted to kind of set the record straight today in a clear and straightforward manner. And I know that you're all busy and you don't need to be bogged down with any misinformation. Today I'm joined by attorneys Julie Proscia and Sara Zorich for this webinar that was exclusively designed for our members. Julie and Sara will discuss SSA's new no-match letters and the necessary compliance steps to address their receipt. Julie and Sara will discuss employer obligations, practical steps that employers should take, and leave room for questions and answer. Before we begin, one housekeeping note. I hope you all enabled your audio pin when you dialed in. If not, at any point, you can re-add your audio pin by entering hashtag the audio pin number you were assigned, followed by a hashtag, which will enable your audio controls. And the audio controls will improve your experience, and it's going to make the webinar easier to manage on our end. During the call, you're all going to be muted. If you have a question, you can use the comment box. Questions will be reserved for the end, and we'll get to as many as we can. And then you can always follow up with Julie or Sara after the webinar is concluded. In addition, Julie has let me know that she will share the PowerPoint presentation, and in addition, we will also be recording this webinar and posting the recording to our download page and to YouTube. So on behalf of the ILCA, I want to thank all of you for joining us, and now I'm going to turn the webinar over to Julie and Sara.
Good morning, everyone. Thank you, Scott. My name is Julie Proscia, and I'm an attorney at Smith Amundsen Law Firm. I'd also like to introduce my colleague, Sara Zorich, who is also an attorney at Smith Amundsen Law Firm, who has a particular specialty in immigration matters. So I think that's her own personal illness and that she really enjoys it. Hey, Sara.
Thanks, Julie.
So we have had the pleasure and the privilege to work with members of the ILCA for about 10 years now. And that has ranged anywhere from Department of Labor related issues to immigration issues to union issues. So it's ranged the gamut. And we've had the opportunity to do so through the hotline for a number of years. As Scott mentioned, in March, the letters went out, and the letters that went out really amped things up because it was an inundation for not just our industry, but for many industries and many of our clients. And so we wanted to talk a little bit for a couple minutes just about what they are and where they came from, and then go into some of the practicalities. So the letters are Social Security Administration no-match letters. What they are is employer correction request notifications. They're coming from the Social Security Administration because there was a differentiation in the numbers that were submitted. So they're trying to identify the W-2s that don't match or mismatch with the Social Security records. In 2018, in late 2018, the Social Security Administration announced that they would be issuing these no-match letters in the spring of 2019, and that's exactly what they did. In March of 2019, they issued them. I think that everybody knew that they were coming, but not everybody realized that they would be coming in such a insurgence throughout industries, you know, that thousands upon thousands of letters would be coming out and essentially hitting everybody within a 1 and 2 week time span. When we're looking at these letters and these correction notices, they are slightly different than the letters and notices that we received about 10 years ago during the George Bush era. And so this is what Scott was indicating, that the gist of the letters, the no match, looking between the W-2 and the Social Security Administration, the Social Security numbers, that gist is the same. It's really kind of the format that's a little bit different. In the previous incarnation, the letters had the names of the employees and the Social Security numbers on it, and then that's how you could match up and be like, okay, this individual doesn't match. These new letters are just provide that you have 32 employees that have a possible mismatch, and you need to go into the business services online to get a password so that you can register, so that you can see the names and Social Security numbers for the individual, so you could correct any errors and submit it within 60 days of receipt of the letter. It doesn't tell you who the individuals are, or even if those individuals are current employees. A lot of times when we've been talking to ILCA members and individuals, the corporations from other segments, we'll get calls where they'll say, like, there's like 64 people on here. I only have 50 employees. It doesn't necessarily mean that it's current employees. It could be somebody that worked for you for 1 day or for 1 hour. It's not until we log into the BSO, the Business Services Online, that we can get the information to ascertain the names and the numbers. So there's an interplay that's going on, and we kind of wanted to explain that because it comes from the Social Security Administration, but it is not just relegated to the Social Security Administration. So the letters are coming from the Social Security Administration, but they have agreements in work sharing with DHS, the Department of Homeland Security, and the Immigration and Customs Services, ICE. And those are really the latter two, which we are more concerned about for our purposes. So the Social Security Administration is looking at it through the lens of wage reporting and the benefits. They're looking to make sure that the Social Security numbers match the W-2s or the 1099s. Their intent is purely to have accurate earning records so that when people get Social Security, when they retire, that's the proper amount that's being bestowed to the benefits. So that is what they're looking for. DHS is not looking for it from that perspective. The DHS is the department that's enforcing our immigration laws. And as everybody in this call is painfully aware of, the DHS and ICE have been substantially more active and aggressive over the past couple of years. And they're looking at it from the perspective of I-9s to make sure that there's compliance with I-9s, and looking at it from the perspective of fines and fees to ascertain what, if anything, if there's a violation needs to occur. And here's an important point to remember. So when the DHS is conducting an I-9 audit to ascertain whether or not we have proper I-9s, the fees that they can enforce include fees for individuals who have constructive knowledge that they are employing employees who are not authorized to work in the U.S. And that kind of comes into play with what Scott was talking about the conflicting information. In the past, DHS has always had the Form I-9 audit and requested copies of the no-match letters. We do not foresee as aggressive as DHS has been and as aggressive as immigration has been in the past couple years, that it is going to magically change in the next couple of years, and that the audits are not going to include and encompass the no-match letters. So from a practicality standpoint, they're going to get the no-match letters that if they're conducting the audit, and they're going to see you had allegedly 32 people that didn't match. What, if anything, did you do with it? Because you have constructive knowledge that some individuals might not have a match. So that kind of takes us to the next component of it, with the conflicting information. If you get 20 attorneys in a room, you will get 20 different responses to things. It may vary by degrees, but you're going to get 20 different responses. We can only tell you, with our experience in this area representing employers, what we are recommending. We have heard different individuals have recommended to do nothing. And one of the reasons is that Social Security Administration doesn't have the ability to find an employer for complying. That's fine, but I don't care about the Social Security Administration. It's not that I don't care about the agency, but that's not our worry. It's like when I'm talking to companies about a Department of Labor audit or an audit regarding classification of employees or misproper classification of employees from exempt to non-exempt employees. You could be audited by the IRS and you could be audited by the Department of Labor. The IRS is the least of our concerns, shockingly. It's like the only time you could ever say that. It's really the Department of Labor. In this case, because of the interplay, although the Social Security Administration is the organization that's sending out the letters, because DHS is asking for those letters, it's the DHS that we're really worried about it. The concern is that if we do nothing, particularly under the aggressive nature of the current administration, that the DHS will find that we have constructive knowledge that there were individuals and we did not review it, that we did nothing in that. And it's through that I-9 audit that then they could charge companies with constructive knowledge, and that knowledge, if it's found, could result in fines and potential criminal action. So that's what we're basing, in part, our basis for why we need to react and why we need to investigate accordingly. Like I said, different attorneys are going to have different opinions. Again, our concern is that we believe that we need to act in order to mitigate any risk. There's an increase in DHS audits. They are much more aggressive in seeking criminal actions. A few years ago, this was rarely the case. This is not a rarity anymore. In conversations that we have had with DHS investigators for our current I-9 audits, they are aggressively pursuing these measures. They are aggressively pursuing actions. This is the same advice that SHRM, the Society for Human Resource Management, has also been given. And when we were on the phone a couple weeks ago with an ICE agent, we were asking about, this is an ICE agent that we know. This is not somebody that we just randomly talked to that day. We were asking not about the landscape industry or anything like that, but that we had heard that there was advice in a do-nothing manner. And her response was, I cannot possibly understand why an employer would ignore that letter. They're going to have constructive knowledge that something's occurring, and that is going to open them wide open. And the reason that's important, because these are the individuals who are the investigators who are reviewing the I-9 audits with the DHS. So I wanted to give you a little bit of that background before we move into the practicalities to kind of get you in the understanding of where we came from with the letters that were 10 years ago, how they're a little bit different, because I think a lot of times when people got the letters, they were like, oh, well, there's no names and numbers here. And that's kind of one of the differences, that through the security measures, you have to log into the portal and then you have to get the number. They tell you it's going to come in 7 days, and it doesn't, because they're overwhelmed, and it's coming in 14 days. And then we need to go on with the steps, but also why we're saying you do need to log on. And the basis for that is because we're concerned because of the cross-mingling with DHS, that it's not the Social Security Administration that runs to the forefront, but to the DHS. So now kind of on to like more of the practicalities.
Thanks, Julie. This is Sara, and that was a great recitation of what's been going on, and I'm going to talk about now the practical matters of what you do. So as Julie said, our recommendation is that you address this letter, that you take the letter seriously. And how do you do that? You get the letter in the mail, and it gives you information on how to log on to the BSO. And as Julie said, the names aren't there the minute that you log on to the BSO. And this is for a security measure, because, you know, let's say you gave me a copy of your letter, and I wasn't your attorney, I'm just Joe Schmo, and I go on there, and I automatically have access to all of the information of all your employees that were on the no match, including the last 4 digits of their social. Social Security doesn't want that. So what you need to do is you need to log in. You'll need to give information to Social Security. They will send a letter to the company, and that's how you will get the PIN and login information. The portal, then when you log on, when you get this login information, and as Julie said, at first, you know, they said you'd get it within 7 days. We're hearing that Social Security in the month of March sent out approximately 575,000 letters. So to say they were overwhelmed was probably the understatement of the year. So it has taken longer for some people. Some people got it right away. Some people it's taken weeks to get. I've talked to some people who called Social Security 4 times because they could never log in. It's been more of a process, but that is the process you go through to get the information. Once you get the information, there's a whole process, and I'm not going to go through step by step of everything you have to do, but I'm just telling you that the steps that you need to do, you need to review your records, you'll need to meet with employees. The way that you address this needs to be done in a non-discriminatory manner. You can't just pick the 4 names. I'm only going to talk to these people and not these people, or these people had, told me this and I'm going to treat them differently. We can't do that. You have one process and you go through the process. You don't terminate, discipline, suspend an employee solely because their name is on the list. Now, that doesn't mean if they don't act when you tell them, about the mismatch, I'm going to go through some other things of where termination would come into effect. All I'm saying is when you get that name and that list and it has 18 names on it, you don't immediately say, you're all illegal, you're gone. That's not how it's treated. You need to treat it as Social Security has indicated there is a mismatch. We need to review our records. We need to meet with the employee and take care of the actions. If you don't obtain the names and you don't do anything, as Julie said, that's when the risk comes in. The SSA letter tells you to log in and get the information. So if you're not going to do that, what I've talked people through is, what are you going to tell ICE? When you get the audit and you say to ICE, why didn't you act on the letter? Why did you choose to ignore it? Or if you chose to follow a completely different plan of action and you didn't log on to the Social Security portal, but instead you came up with your own plan to deal with it, how do you explain that to ICE? And as Julie said, when we talked to one of the ICE agents, and again, it had nothing to do with landscapers. I know the agent through other audits. Her reaction was, why in the world would someone not, when they got a letter from the government, not take it seriously and not act on it? And you have to understand, they're all government officials you're dealing with. And they all think in that way. They think an employer would never not log on unless they were trying to evade the law, trying to be shady, or trying to hide something. Now, again, if you do nothing, that is your option, but we're telling you what we see as the risk. Under this administration, they have been extremely aggressive, as Julie said. They're only increasing their enforcement efforts by doubling, tripling the audits that we're seeing on a monthly basis. They don't have sympathy for companies that don't comply. They don't. So, or they're not going to have sympathy for a company that, when I say tried to play cute with the system. That's not what they want to see. So that's why we've come out with the advice we have and why we're talking about this. Now you get the names, and yes, you need to act on them. You can't just get the names and then throw it in the circular file and do nothing with it. What is the risk, cost, benefit analysis? Yeah, when you get these names, you can lose workers because they tell you that's not my social, it isn't mine, and I can't get a new one. Well, you need a social security number in order to report wages. So if they can't give you a social security number to report wages, you can't continue to employ them. If they say, I don't have a number, that wasn't my number, and I can't get one, well, then you can't continue to employ them. You can have workers that tell you, hey, I'm not legal. I talked to a client the other day, and the reaction from 7 of the 8 people was, why has this number worked for so long? Why is this happening now? So I was a little taken aback by that reaction because the people seemed a little emboldened by the fact that they had gotten away with using a false number for 15 years. And my answer to that question, when I get it, is the reason that we saw more now is, think about it. 10 years ago, technology wasn't where it is today. Yes, we had, advancements, but FSA has increased their databases. We have the ACA now, so Social Security has much more information, through information sharing than they've ever had. So I imagine that maybe if you dealt with this 10 years ago, if you're one of the companies that saw these letters 10 years ago, that maybe you didn't have as many names as you're getting now. Or maybe someone's name never popped in prior years. That can happen. But now, the reason you're getting the letter is because Social Security's database that they searched when they got your W-2s at the beginning of 2019 for the 2018 year, they went through and compared those to their database. And that's what the list is based on. The other risk is, I'm telling you that you can have people, after you notify them of this, you can have workers fail to show up again. And again, what we do is, each of your situations with how you meet with your employees, how you address it, that's an individualized situation because it all depends on how many people you have on the list, how many people are already no longer with you, how many people you might have at different locations. Again, do we have translation issues we're going to have to deal with? Are we going to have to address, certain people that we don't see very often? Maybe they're in another plant or another location. Maybe you've got crews that are in Iowa right now doing work. How are we going to meet with the person? All those things. And, those are strategies that you have to decide and think about it. How am I going to address this letter? Okay. Logging on, this has been a big question. If you log on to the Social Security and get this information, are you signing up for E-Verify? The answer is no. E-Verify is a completely separate system, a completely separate government program that is used in conjunction with the Form I-9. So for E-Verify, you have to complete the Form I-9, and then you would complete E-Verify. E-Verify spits out then to you whether the person is authorized to work in the United States or whether more information is needed. E-Verify is not required in the state of Illinois. It is required in other states. So if you happen to have businesses in other states, you need to check those states. But unless you are a government contractor that has a government contract with the requirements that mandate the FAR E-Verify clause, you do not have to use E-Verify. If you are considering using E-Verify, I would talk to counsel again about that issue, just so you understand what the compliance requirements are of E-Verify. So again, I've been involved in E-Verify, audits also with the government. And so I've had clients, sign up for it and then never use it. You don't want to be in that boat. You want to make sure if you're going to sign up for it, it's another compliance issue you're going to have to deal with, and you need to do it accordingly. The SSA letter tells you to log in and review the names and the information and submit any corrections within 60 days. That's what the letter says. So again, I've talked to people about this issue. My advice to you is you don't wait till the 59th day you have the letter to log on. I know it's a process. I know you're going to probably talk to counsel, talk to them about the letter. You've got to go on to the BSO, all of that. Again, at the end of the day, what you want to show is that you acted in good faith, that you had a reasonable explanation for your actions. If you needed to wait 3 weeks because you were out of the country or your HR manager was or something like that, document that. Show what was our process. Now, for Social Security, they want you to correct it within 60 days. Now, you might not have any corrections. If you didn't make a mistake, if you didn't transpose the numbers, or someone doesn't tell you, hey, yeah, last year I had a different Social Security number, that wasn't it, then you're not going to have a correction for the Social Security Administration. Years ago, when we had the other no match letters, the Department of Justice had come out and said, listen, you've got to give people time when you get this no match letter to address it, because they are going to have to go to Social Security, talk to Social Security. It takes time to work that out. They suggested in the E-Verify context that it might take 120 days for them to work this out. So that's what we're talking about. You give people time. If someone tells you, that's my number. I'm Sara Zorich. I don't know why my number is popping up on there. After you meet with the employee, they say, yes, I'm going to go to Social Security and meet with them. I want to work this out. Okay, we're going to give them time to work that out. It's not going to be 5 minutes. We're going to give them a period of time, and then you're going to check in with them. The Department of Justice guideline was a reasonable period of time to act on, yeah, that's my number, and I want to address it. If the person tells you it's not their number and they're not going to go to Social Security to get a new one, you're not going to give them 120 days to just think about it. You're not going to do that. If they say to you, that's not my number, I can't get a new one, then for wage reporting purposes, we don't have a social. And they're telling us they can't give us one. So we can't continue to employ that person. Julie talked about constructive knowledge, and, there's actual knowledge. If somebody during this process says to you, or said to me, hey, Sara, I'm not authorized to work, we can't continue to employ them. The minute they open that box, they open their mouth and say that, you can't unknow. So you need to act upon it. If you have knowledge talking through the employees that establishes they're not authorized to work, if they say, again, I can't get a number, there's no way I can go to Social Security because, they can't issue me a number, I can't get one, well, then you have knowledge at that point. Again, both for Social Security and then potentially for immigration. So, ICE and DHS are going to look at the circumstances of the particular situation and use a reasonable person standard. That's why, when I talked to that ICE agent, her response was, why would any employer do that? Why would they not act on the letter? That's why we brought that up, because, those are the people who are going to be first judging whether you had, was what you did reasonable. And it's not going to be only the ICE agent, okay? It's going to, especially in a constructive knowledge situation, it would be vetted up through the ICE agent's manager, up through their legal system and their attorneys for the Department of Justice and all of that. But I'm just saying that, that's the way they think. So you have to be aware of the people that are judging you. How do they think?
So I want to jump in real quick on what Sara was saying. So a few slides back, Sara talked about the initial conversation with your employees, right? The ones that, not the ones that are no longer there, because obviously you don't need to check them down and try and find those individuals, but the individuals who are your current employees. And when you're having that conversation, Sara was talking about there was the pro and cons, right? Of like, everybody's concerned because you're going to lose their workforce and everything like that. I think that you could absolutely mitigate the concerns with losing individuals and the concerns with the actual and constructive knowledge based off of how you frame it. And what I mean by that is to let the individuals know that we receive Social Security no match letters for a number of individuals. These do not mean that we believe that there is anything improper about your Social Security card. It just means that there could be something as easy as a typo in the numbers. And we just need you to take a look, go take a look at your documents and figure it out. If it's not a typo, then you're going to need to talk to Social Security Administration to do that. I know that this is an incredibly busy season right now and everything's running ragged. So I also know that this is going to take a little bit of time for you to do. Because the reality of the situation is that we are in high season. If it ever stops raining, but we are in high season, which means not only us, but our employees are running all over the place for the next couple months. So yeah, it's going to take them a couple weeks to get back to you. And that is absolutely positively reasonable and good faith, like Sara said. So you could let them know that you're going to check back with them in a couple weeks in order to do it. This is not something that we need to be hounding them on a daily basis. I think when you put it in that perspective, that gives them a little bit of ease of comfort that it's not, oh crap, I can't show up tomorrow because of this. You are going to check back with them. And when you check back with them, if they say, I contacted Social Security Administration and they're super busy and I can't get a hold of them, or I'm still looking for the documents, okay, we could get back to you, we'll get back to you. So I'm not trying to minimize the importance of this. I'm just saying that you could absolutely mitigate the concern level that it amps up to, because I think that for a lot of individuals, regardless of their legal status within the U.S., when they hear that there's a Social Security no match letter and that there's some type of look into their status, they are automatically thinking of ICE agents pounding down. And so we really want to not emphasize that level of concern and truly bring it back to this could be as much as a typo. I'm not assuming anything. I'm assuming that it was a typo, and unless something else pops. So go on, take a look, and for now, just go back to work.
And I absolutely agree with that, Julie. The other thing, I just was reading some else. I'll let you continue if you've got anything else, Julie.
No, jump in.
One of the questions here.
So at this point in time, Sara's got all of the questions that you guys submitted. We're going to start opening it up for the questions. What we wanted to do is kind of give you the basics. So a lot of it is going to be very specific. So we're going to have, we told you that you're going to have that, you're going to get the letters, you're going to get the information, the numbers, and then you're going to sit down with your employees and you're going to talk to them, the ones that popped. A no match, and you're going to sit down and you're going to talk to them about how, this came up and we need to, ascertain, what's going on and everything like that, go fix it, like we talked about and everything like that. We're going to check back. What we do next with them is very, very individualized. And that's what we've been talking to you guys about more in depth when we're talking to you about your situations, because the process up until that point is very rudimentary for everybody. You have the conversation, you do that. What happens next is dependent upon what they say. If somebody comes back and says, like Sara said, like where you have the actual knowledge that, oh my God, I'm totally illegal, I don't have it, well, then we're stuck. We have the actual knowledge and we're going to have to effectuate the termination. If somebody comes back and says, I can't find the documents, I'm looking, we moved 5 times, you're going to give them additional time to do it. And as Sara said, that gets you to, it would be reasonable for up to 120 days for that. And if you do the math, this is May. No, this is June, but you probably got the letters, in anywhere between March and May. So where that takes you to. Sara, I don't know if you have the questions up or not yet.
So,
yep.
Okay. Okay. So one of the questions was, are we going to be providing everyone with a script? And that's something that we've been talking with individuals who have engaged us, because, the script is based on your company. Yes, I've got a script of things to do, but it's based on who's on the list, how many people you have to talk to. I always talk to people about, choosing the person you're going to talk to first. We go through that process. So, we don't really have a generic script that we can provide to anyone, but we do have, we're here for advice and counsel if you want to engage our services. But that's where we're at on that. Julie, anything else to add on that issue?
Yeah, I would just say that, we could tell you generally, we can't give you a script because, like Sara said, it's super individualized based off of the composition of your workforce. I have individuals who have said, you know what, I've known my guys for 20 years, and I could just walk in there and be like, hey, just take care of this whenever you take care of this, and it's done. They don't need a formal script. And I have some people who say that, we have a very rotating workforce, and this is, they're very skittish, or these are all family members. And so we have to address it differently. So what we'll do is we'll go through with you and kind of walk through for your purposes what suits best for you. But generally speaking, what you really want to do in that initial conversation is give the intonation that you receive this, not just you. Thousands of companies across the country receive this. This wasn't targeted specifically at X, Y, and Z landscaping. This wasn't targeted specifically at you. This is something that's been going out to make sure that everybody gets paid their Social Security when they retire, that a lot of these things we're finding out are to just be typographical errors, and we're just looking and working with them to try and fix any errors that we have, and if that means that they need to go back and check their documents and see if, maybe when they gave it to us, we wrote it down wrong, and they're giving us, the Social Security card with the right number, that's, all of that is fine. So you're really just, I guess the most general advice that I have for everybody is we don't want to, because of the discrimination component of it, right? We cannot assume that these no match letters automatically mean that these individuals are illegal. And B, because we like our workforce. We don't want to lose our workforce, A, in high season, and B, because we respect and value everybody. So we want to do it with the least amount of scare that we can. So that's the general that I have, and that don't give them the impression that you're going to check back tomorrow, but that, we'll circle back in a couple weeks, and we're going to work together to see what we need to do. So this is a process, you're working together with them. Think of it like ADA and reasonable accommodations. You're working together to do that.
So I got a couple questions. It seems like a couple people have both had the same issue. When they went on to the BSO, it did not list any names for them. So if that's the case, I understand that on the BSO, it's saying in certain circumstances, no further action is needed. I would still follow up with, if you can't get the names, that is concerning to me. If you're getting the names, it says no further action and then lists the names. I'd have to talk to you individually to see what you're getting, what the screen is looking like. Because a number of people have said that it seems like they either can't get the names, and then what I would do is I would call Social Security, and if that's the case and they say to you, you don't need to do anything. We aren't posting the names on your site. I would print off a copy of what your screen shows, and I would write down and document that on this day I called Social Security. They told me I would not have access to any of the names, and then I did not need to do anything further. If that is the message that you're
is to do a screenshot of those pages, because
yes.
What you want to happen is later on for somebody to say, well, that's not what it said. Oh no, I have a screenshot on that day. You have a obligation to take reasonable steps. Reasonable steps doesn't mean logging on every single day to see if that changes.
No, exactly right. And if it's Social Security is in the portal saying we're not giving you the names, then I would just call Social Security to confirm that, and then I would document that you made that call and print off the screenshot. So someone asked, do I recommend giving them the template letter on Social Security? Yes, there is a template letter, and yes, I do recommend using the letter. I've modified the letter a bit for clients, but yes, that's a good place to start. One question was, is it okay to use another employee as an interpreter? Yes, but I would want to make sure that the person that you're sitting down to talk to feels comfortable that that person is going to be interpreting. So I would make sure that when they sit down and say, I've got an important issue to talk to you about. Are you comfortable with so-and-so interpreting? Just make sure. So there was a question too, if the information says, or if the person gives new information, okay? Now, if the employee gives you new information, says to you, hey, I've got new information, that's a different process too, because that might trigger you doing a new Form I-9. It doesn't necessarily trigger it. So we'd have to know also, when did that information become applicable to them? Okay, so we'd have to talk through those. Someone else said,
what we've been doing, sorry, I didn't mean to jump in on you, Sarah. What we've been doing is having you guys, once you have the conversations with them and they come back with the responses, is because it is so individualized based off of what they say, like we'll just set up a half an hour time, set aside 30 minutes time and kind of go through with them so that you can be like, okay, you need a new I-9 for this. This one would result in this, so that you can, because it's hard to, we're not trying to be evasive, but it's very hard to tell you, because it's going to based off of what they say, what to do in all circumstances. Sorry.
No, that's perfect. And okay, so someone said, again, they logged on, they got the names, and the Social Security page says it's informational. I hate that it says that, because I think that's extremely misleading. I think that's misleading to employers to say, oh, here's the names, now it's just informational. Well, they gave you a letter saying that those were the no matches. I have concerns that if you have the names and you rely on the fact, oh, this is just informational, and don't do anything about it, that ICE is not going to take that same position. So again, if you can't access the names, that's one thing. If Social Security, when you log on the portal, they say, we don't have any information to give you, then again, document that. But the idea that Social Security tells you, it's conflicting messages. They send you a letter to take care of it, and then you log on and they say it's just informational. But now you have the information. So again, from an ICE perspective and from a DHS perspective, act on the information that you've got. So Julie, that's all I had for questions, it looks like. Scott, anything else?
I actually do have a question myself. When
Sure.
these did go out the last time during the Bush administration, did they go out every year? Was it just a period of a few years in a row?
There were a number. Yeah, go ahead. Sorry to interrupt you.
No, I was just curious as to just, what we might have to look forward to, not just this year, but in future years, based on precedent.
Yeah, so they did go out year after year. We didn't see the mass that we saw this time. And someone else asked me that question too just recently. Social Security has not indicated whether they're going to send a follow-up letter They haven't told anyone. We don't know. This is new waters for us. So we might see follow-up letters coming later this year. I anticipate they're going to continue their actions, especially as long as we are under this current administration. And I would anticipate the letters are going to come again next year. So Scott, I don't think this is a one-off this year and we're never going to see it again. But I'm not sure how they're going to follow up this year, if they are at all.
Thank you. Any more questions? Leave it open for just another few seconds and then we'll close it down.
So I did have one more question. Do you feel the letters will be a driver for future DHS audits? So what we do know right now is, and this can change, but right now Social Security has said they are not sharing the companies who got no match letters. They're not sending a Excel spreadsheet to DHS, okay? That's not what's happening. Now, again, I can't promise that won't happen in the future, but they've said right now that's not what's happening. I don't feel right now that the letter itself is going to trigger an audit for DHS for you. But again, as I said, I don't know what the future holds, and they do have information sharing, but I don't want you to think I got this letter in March and DHS just found out about it, so of course they're coming knocking on my door next week. But we do know that DHS is more robust than they've ever been, so you could get an audit. And this is, so how you get audits from DHS is, number one, they target certain areas, certain industries. Last year, just so you know, in 1 month, they hit 250 manufacturing companies in Illinois and 2 surrounding states. In one day, I got 6 calls from clients who, in the manufacturing industry, got DHS notices that day. So that's how they work. They also work on, you know, if you get a complaint, they also work on, you know, we've seen an increase in criminal activity, meaning that DHS is going after employees of yours who have criminal action. So I got a call just recently from 2 different clients. DHS showed up. They didn't bring an audit. They brought in the security and they asked for the employee, and the employee was taken away on the site. But that only happens, again, if that employee has some type of criminal action that the DHS is focusing on. So at this point, I'm comfortable saying the letter is not automatically going to get you an audit from based on what SSA has said, but I can't say how long that advice is in play. Again, if Social Security changes their protocol, that could change.
And let me just clarify that so that everybody doesn't misunderstand. What Sara just said is that Social Security Administration is not sending DHS the names of the companies for the audit. That does not mean that when DHS audits, they don't ask for the letter. So one is not the same as the other. They're just not giving them the list right now of these 500,000 companies had no matches. But if you happen to be audited, and we are in a target industry, right? Landscaping is a target industry for this, then they will ask if they keep consistent with what they've done in the future for your no match letters for I-9 audits. So I just wanted to clarify that.
Yeah, thanks, Julie. And then we got one more question, you know, what to do if DHS shows up? So if DHS shows up with a subpoena and they want to arrest your employees, you're going to give them access to the employee whose name is on the warrant. I mean, you can't stop them. If they show up with an inspection letter, you do not have to give them anything that day, okay? When they show up with a notice of inspection letter, it's going to be a notice of inspection and a subpoena. That's different than a warrant. If they are saying, we want to inspect your I-9, you have a minimum of 3 days to give them to them. So you don't need to give anything right then. Do not divulge any information. You listen to what they say, you take the information, and then you call your lawyer and you make a plan to deal with the I-9. But you do not need to give the I-9s that day. And I will tell you, this is my advice always. The DHS agents on that day are friendly. They are. They're not your friends. So don't assume just because they're nice that they're not continuing their audit. So, but don't give them anything that day.
I would go further with that to say anyone. So if Department of Labor shows up for a DOL audit, if anybody for wage and hour type of stuff, unless they have a subpoena to enter that day, never ever give them any documents or let them enter that day. Let them know that, you need to go somewhere, you have a meeting, your hair's on fire, you're going to call counsel, whatever it is, but don't let them in and don't give them documents, and train your whoever's at the front desk to the same thing. I can't tell you how many times we've had problems where a front office individual, a receptionist, has bound the company to information that was absolutely inaccurate, but that they thought were just being helpful because the ICE officer, the DOL investigator, it just seemed nice and friendly. They're not your friends. Regardless of how much we think they are being friendly, they could be nice people, but they are still there for an audit. Or they come in and they're very heavy-handed where they're like, well, you need to do this right now. You don't. And if you don't have a labor and employment attorney on speed dial, we have the hotline. So call, because at least then you could get us on the phone at a minimum where we could give you guidance for that day of tell them this or hand me the phone.
And just so you know, for Department of Homeland Security, if they're going to do an I-9 audit, they're always going to show up with 2 agents, always. That's how they work. And you can request a copy to see their badge and take a copy of their card. You don't need a copy of their badge, but you can ask to see it, and they need to show it to you. Same thing with Department of Labor. They're not going to come with 2. The DOL usually only comes with 1 investigator, but absolutely you can say, can I see a copy of your badge? And can I have a copy of your card? So again, I just want you to understand the process of what will happen when they do, come in, and those are absolutely things that you can ask for. So I think that's the last question, Julie. Scott, anything else?
No, I just want to thank you both for giving us your time this morning. I also want to thank all the members who were able to join us. I know this is not an easy time to break away, especially when the sun is shining. At least I think it's shining. I'm in a conference room, but it was shining an hour ago. But I know this has been a scary time for a lot of people. We don't necessarily need one more thing to worry about, but yet here we are. And my advice, reach out to counsel when you can, when you're faced with something before the S hits the fan, just because being a penny wise and a pound foolish, I think when it comes to legal counsel can really blow up in your face, especially with something as important as labor in this given year or in the coming years. So just be careful out there. We will be recording this and putting it on the ILCA website. And then posting a notice. And once again, Julie and Sarah, thank you very much for your time this morning.
Thank you very much.
Thanks for having us.